You're listening to closing arguments in the hearing to determine if Fulton County District Attorney Fani Willis should be removed from former President Donald Trump's general election subversion case being heard in the courtroom of Fulton County Superior Court Judge Scott McAfee. Trump and other defendants in this election case are alleging that Willis's romance and romantic relationship with a special prosecutor she chose, Nathan Wade, has created either a direct conflict of interest or the appearance of conflict of interest. And that's really the key in Georgia law. If there is, as the judge determines, a conflict of interest or the appearance of one, then the District Attorney Fani Willis can and should, under Georgia law, be disqualified. And of course, if she is disqualified, then there's a somewhat elaborate procedure that would need to be engaged in to find another attorney, inevitably delaying the prosecution of the underlying case or giving that new prosecuting attorney fresh eyes, and maybe some of the charges might entirely be dismissed. In other words, tremendous amount of limbo would be visited upon this case if, in fact, Fani Willis, as the District Attorney of Fulton County, Georgia, were to be disqualified. I'm joined here at the table by Nicole Killian, our congressional correspondent. Nicole, you've been down to this courtroom, in this courtroom. You've been covering this case for a very long time. The stakes are high. What we heard there was the counselors for the defendants making very aggressive charges, alleging that Fani Willis and Nathan Wade engaged in an elaborate cover-up, a scheme, that they benefited financially from their personal relationship, that they didn't disclose it to the court, and then, having been accused of having this relationship, did all sorts of things to keep information from the public and the court. A pretty aggressive posture from the defendant's attorneys.
And also accusing District Attorney Fani Willis of playing the race card as well.
And the God card at the same time, in the same speech.
And trying to prejudice a jury in the city. Now, granted, they aren't on trial, but certainly as you raise, you know, a lot is at stake in terms of whether or not she and Special Prosecutor Nathan Wade could potentially be disqualified from this case. I think another fascinating dynamic of what we've been watching is, once again, the tables are turned on the District Attorney. I mean, you basically have these defendant attorneys for clients she's trying to prosecute over election interference, questioning her and Special Prosecutor Nathan Wade's relationship. Certainly it does matter in this case, but it's also very eye-raising just to see the tables turned with a defendant questioning a prosecutor in a case that is still underway. But that being said, look, we will hear from the state, which will make its arguments, each side, of course, getting 90 minutes apiece. But the core part of their argument, I expect the state to knock down, is this notion that Nathan Wade and the district attorney were potentially being untruthful. I mean, we saw the district attorney and Nathan Wade both take the stand last month defending their relationship. Obviously, what is still very key is the timetable of their relationship. You know, what some of these defendant attorneys are arguing is that this relationship started before Nathan Wade was hired. We know from testimony from the district attorney and from Nathan Wade, they both said that their relationship started in 2022. After he was hired. But what some of these attorneys want to point to are text messages, are cell phone records that they believe prove otherwise, in addition to testimony from another witness who used to work in the district attorney's office, who did say on the stand some time ago that she believes that the relationship was underway beforehand. But why that matters is because, and actually it looks like the district attorney is in the courtroom as we speak. You know, I'm very curious, actually, if she will make the closing arguments or if she's just there to observe. I mean, we did see during her testimony she was very defensive, combative, but also very explanatory about the relationship, wanting to make sure that she got her position out. So we'll be curious to see what role she plays, if any, as we await the state's arguments.
Could be a very dramatic moment with the district attorney Fani Willis present in the courtroom. I want to bring on our CBS News legal analyst Ricky Clayman, who's also been following today's hearing. Your impressions, Ricky?
One of the things that we have to remember is that these defense lawyers have a duty to go forward with this motion. This is not something that is unethical. This is not something that is needlessly combative. This is a situation where information came to attorney Ashley Merchant over a period of months by Terrence Bradley. Terrence Bradley, who was the partner of Nathan Wade, he was also his divorce attorney, sent not dozens, it may be hundreds of text messages. We certainly know it's a myriad of them over months, leading Ms. Merchant to be able to file a motion, encouraging her to file the motion because he had the information about the relationship of Nathan Wade and Fani Willis. An attorney in the position of Ashley Merchant fully had the duty to file this motion. I'll say this without fear of contradiction. This case is not getting dismissed. However, the one question that does remain is whether or not Fani Willis and or Nathan Wade will be disqualified from continuing the case. The fact that it may create a delay, the fact that another prosecutor may have to look at it anew, well, that's just a consequence of reckless conduct. In this particular case, I think I've said it before, the conduct here of Fani Willis and Nathan Wade was stunning in its recklessness. Now, does that mean that they get disqualified? Perhaps yes, perhaps no. One thing we know for sure, it is on the mind of this judge that even if he does not disqualify the district attorney as well as Nathan Wade, that the one place that these complaints are going is down to the Bar Association. And we know that there are groups of people who are looking at this conduct. It's so basic to a lawyer, particularly a prosecutor, that you cannot have an appearance of impropriety. That is the problem here.
Ricky, I believe the judge, Fulton County Superior Court Judge Scott McAfee, has returned to the courtroom. There's been a brief recess. He's now back in the courtroom. The proceedings are continuing. We will now hear from the state in defense of District Attorney Fani Willis, possibly the district attorney herself. We will wait and see. Let's listen in on the proceedings.
The floor is yours.
Good afternoon, Your Honor. I want to start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Ms. Daisha Young, Ms. Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically, in his presence or to him, said that Ms. Willis and Mr. Wade were in a romantic relationship, and that Ms. Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive admissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to...
So, but wait, are you making an argument I should make inferences based... Now, these would be attorney-client privileges, or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share. Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication. And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard what the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and did it based or got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple the defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we before Your Honor. They were not able to provide any evidence as to, or to the contrary of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court because of this failure that their assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Ms. Willis, as the District Attorney of Fulton County, and Mr. Wade, as the Special Prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the District Attorney's Office. And looking at
what I think you're talking about, is this Ventura?
It's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that what the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced as they argued here today and in their filings. And I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney is that you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that Your Honor that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Lee v. State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is a case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court the cites are misleading, many of them are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Yes. Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety would be the grounds of disqualification.
Well,
there are a number of these cases that seem to exclusively rely on the appearance of impropriety.
right.
Well, they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. But they acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety?
As it relates to a prosecutor or district attorney, yes, that is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court in reading those cases is that I found that they kind of fell into 5 categories, that some that didn't concern disqualification at all, some that determined or that were about, I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome, and then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction. And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today. The first, McIver v. State, has nothing to do or has nothing related to the disqualification of anyone.
I mean, I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if there are more... All right, keep going.
So as it relates to one of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regency v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and it didn't pay back in cash. It was
all right. Let me explore this one a little bit. Mm-hmm. So, in addition to you're saying it's only an actual conflict. Are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about, or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So, what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would be necessary and appropriate, because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution. Correct,
as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because, as Your Honor just said, if there's an instance where an officer's lying, or where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless, because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure or the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, which you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required. In the series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest, in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides. You've heard all about Whitworth. So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that it must be that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured. So what I would reference to the court, as was brought up earlier in Lyons v. State, 271 Georgia 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context? So we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality. Was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought, if you have any reactions.
Well, I think what Your Honor just said is pretty on point in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I guess I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and
but I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it is applied post-conviction versus pre-trial, during pre-trial issues. And what I would say to the court is that.
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing.
Legal analysis, that is.
Well, I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. What I can't do at the moment is point exactly to the page. At the end of the state's argument, I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about, the footnote where he references the appearance standard.
Yes.
All right, I'm looking at it.
Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction, based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pre-trial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety. which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State 275 Georgia, Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right. But that's a facted issue, whether it was, split even, or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hands is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house. That was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.